Hello and welcome to the podcast on comparing data protection laws across jurisdictions. My name is Vishal Kavanikar and today I am going to present a brief on the comparative study of the key global data protection frameworks focusing on GDPR, the DPDP Act of India and the California Consumer Privacy Act. My goal here is very simple to give you clear practical insights into the why these laws matters, how these laws differ and how to stay compliant no matter what geography you work out of. Before we start, a quick disclaimer: this podcast is for the informational purposes only and does not constitute any legal advice. The explosion of the digital transformation across the globe has led to a sharp increase in the volume of the personal data being collected, stored, and processed. As the digital transformation continues to drive the business innovation and operational efficiency, the importance of data privacy and protection has reached unprecedented levels. The increasing frequency and sophistication of data breaches underscores the necessity of the robust data protection measures. This shift, while enabling business growth and service personalization, has also introduced a significant data privacy and protection risk. In response, the regulatory bodies across the world and the jurisdictions have tightened the data protection laws and have enacted comprehensive data protection laws aimed at safeguarding the rights of each individuals and ensuring accountability for those who are handling such kind of a personal data. But then why there is a requirement for these kind of privacy or protection laws? In the past 1 decade or so, we have seen major data breaches and their impacts throughout the world. Few to name. First one was the target data breach of 2023. In this case, the cyber criminals breached the target via third-party HVAC vendors' stolen credential after a phishing email attempt. Using that access, they provided into target's internal network and deployed the malware to their POS terminals. The malware scrapped unencrypted card track data from memory and during the peak holiday season, especially on the Christmas period. The compromised data count was around 40 million payment cards data. Additionally, roughly around 70 million personal data like names, address, phone numbers, and emails were stolen. This data breach signifies a lot of security failure, one of which was the weak third-party access controls, lack of mandatory multi-factor authentication, poor configuration, like target security system failed to detect malware installed on the POS terminal, and the malware was designed to capture card information during the transaction. Network segmentation gaps were also noticed because vendor portal access, the access was through vendor portal, and the hackers were able to reach the payment card environment, which shows that there was an inadequate isolation. Endpoint and POS hardening gaps were noted because no effective application of whitelisting, RAM scrapping defenses were available. Also, the intrusion detection system did not trigger any alert because malware communicated with the external server using an encrypted channel. Now, this led to a lot of penalties and onto the target. Target faced around $18.5 million multi-state AG settlement in 2017, class action consumer settlement for 10 million in 2015, plus credit monitoring and other remedies. Card network bank settlements about 67 million for Visa, 19 million for MasterCard. Total cost related to breach exceeded 200 million, and target CEOs and CEO and CIO has to resign from their post due to this particular breach. The second, one of the biggest data breaches that we had seen is for the Equifax data breach in 2023. In this case, the attackers exploited an unpatched Apache vulnerability in the Equifax online dispute portal. The timeline of the vulnerability was very interesting to note. The vulnerability was disclosed in March 2017. The intrusion began in May 2017, which is 2 months right after the vulnerability was disclosed. And public disclosure of this was made on 7 September 2017. Roughly about 147 million US customers were affected due to this data breach. There was an international impact as well because Target had some international customers as well. So roughly around 15.2 billion UK records and 19,000 Canadian consumers records were also stolen. The data compromised in this case was names, social security numbers, birth dates, addresses, some driver's licenses numbers, credit card numbers, and dispute docs with PII. In this case, the security failures happened due to non-patching of the publicly available advisory and internal notices. Also, Target didn't have a complete set of IT asset management, which led to the missed identification and the remediation of the vulnerable system. They also they also failed in terms of monitoring because Target was using an expired TLS inspection certificate left on the network monitoring and IDS blind for the months. The inconsistent data encryption, key management, and excessive data retention increased the impact of the breach. As a part of a penalties and settlements, Equifax has to pay 700 million into global settlements. For their UK customer data breach, roughly around 500,000 pounds were fined by the UK ICO for them, which was a pre-GDPR Data Protection Act of 1998. As a consequence, again, CEO, CIO, and CSO has to resign from their post, and uh, Target were involved into significant remediation spend, lawsuits, and long-term oversights and obligations. Another one, a big data breach in the European Union, what we had seen in Marriott International data breach of 2018. The breach actually began in 2014 when Starwood preferred guest reservation system, which was acquired by Marriott in 2016. The attackers used a remote access Trojan, and credential harvesting tools like Mimikatz to infiltrate the system. The intrusion went undetected nearly for 4 years, highlighting severe monitoring failures. Marriott were able to discover this breach only in September 2018 via security alert and disclose it publicly. Approximately 500 million guest records were compromised, including names, passport numbers, and payment card details. The security failures, what we noted here was including weak password policies, poor access controls, and lack of network segmentation. Marriott also failed to patch the outdated system and lacked adequate logging and monitoring. The breach exposed also the flaws in Marriott due diligence before they acquired SPG Starwood Preferred Guest acquisition. The UK's ICO fined Marriott for $18.4 million pounds rather, sorry, under the GDPR for failing to protect the customer data. A separate $52 million settlement was reached with 49 US states and for the similar violation. Marriott did not admit the liability but agreed to overhaul its overall cybersecurity practices. So, friends, these were some of the big data breaches that we had seen, and there were certainly certain lessons learned from this. That one should use strong passwords, two-factor authentication should be implemented for added security, updates of software and systems to protect vulnerabilities on a regular interval, continuously monitoring your network traffic for unusual activities, incident management, establishing an effective incident management response plan to address the breaches. Now let's look at the overview of the global data protection laws. As I said, I'm going to compare three major data protection laws: the GDPR, DPDP Act of India, and CCPA of California, USA. Let's look at the focus area of scope and applicability. The GDPR applies to all entities processing EU residents' data even outside the EU, while DPDP Act applies to digital personal data of individuals in India or targeting Indian users, while CCPA applies for non-profit entities meeting thresholds and handling California residents' data. For the legal basis for processing, GDPR requires consents, contract, legal obligations, vital interest, public task, legitimate interest, while DPDP mandates consent or legitimate use, example, legal obligation, public interest, and employment. While CCPA, there is no legal basis required. it only focuses on consumer rights and business obligations. Consent requirements. Consent requirement in GDPR must be freely given. It has to be very specific, informed, and unambiguous. For DPDP Act, it must be free, informed, specific, and revocable, verifiable for children. And for CPRA, opt-out model, CPRA adds opt-in for sensitive data and automated decision-making technology, that is ADMT. Now let's look at the data subject rights across the three frameworks. The data subject rights for EU states access, rectification, erasure, restriction, portability, and objection. We will look at this more detail later on in our podcast. For DPDP, access, correction, erasure, grievance, redressal, and right to nominate are present, while the CPRA gives right to know, delete, correct, opt out of sale, share, limit sensitive data use. Regarding children's data protection, all the three uh, frameworks provides good security. In GDPR, it requires parental consent for all the children under age of 16. In DPDP Act, verifiable parental consent under the age of 18, and it also bans profiling and behavioral tracking for children. In CPRA, requires an opt-in for a sale of data under age 16. CPRA adds stricter protection for the children's data. In terms of data breach notification, and under the GDPR Act, any data breach has to be notified to authority within 72 hours. Individuals if high risk. In case of a DPDP Act, with the data breach has to be notified within 72 hours again. Individual if harm is likely. If the data breach gonna cause harm to the individual. In CPRA, you must notify the consumers. CPRA adds risk assessment and cybersecurity audits as a requirement in case of a data breach. Cross-border data transfer. In GDPR, it is allowed with adequate safeguard, that is adequacy decisions. In DPDP, the cross-border data transfer is allowed to approved countries only. Restriction based on national interest is the key. In CPRA, no explicit restrictions, but must disclose the third-party sharing of the data for the cross borders. In case of an enforcement authority, supervisory. In case of a GDPR, there is a supervisory authority in each EU country which is available. In case of a DPDP, there is a Data Protection Board of India, and for a CPRA, there is a California Privacy Protection Agency. Accountability and the governance. In GDPR requires data protection officer, data protection impact analysis, that is DPIA, and records of processing. For DPDP Act of India, significant data fiduciaries must conduct the audits. It also mandates the requirement of DPIA and appointment of a DPO, that is data protection officer. The CPRA mandates risk assessment, ADMT disclosures, and internal safeguards. Now, coming to penalties for the non-compliances, the GDPR mandates up to 20 million euros or 4% of the global turnover of the organization. In DPDP, it is up to 250 crores Indian rupees for fiduciaries, rupees 200 crores for breach of notification failure. For a CPRA, up to $7,500 per intentional violation and $2,500 for unintentional violation. Privacy by design and default. I think this principle is mandated for all the processing activities under GDPR. In DPDP, it is required for significant fiduciaries, encryption and access controls mandated. For a CPRA, it is encouraged to have, CPRA encourages to have privacy by design and default. However, CPRA adds ADMT governance and data minimization controls. Third-party obligations. For GDPR, controllers must ensure processors comply. In case of DPDP Act, fiduciaries must ensure processors meet the equivalent standards. In CPRA, business must disclose third-party sharing and honor the consumer rights. Now, after looking at all these comparisons, what we have seen is there are critical trend in the privacy regulation. There is a tantamount shift towards the individual control and consent-based model. There is an emphasis given on the data localization, and there is rise of sector-specific regulation, and there is a greater regulatory cooperation across the borders. Emerging laws being addressed to data processing in AI, that is artificial intelligence, including automated decision making restriction and AI biases. Now let's understand what are the common PIs and SPI data types under these three frameworks. The terminology used in GDPR is for personal data is personal data in specific categories of personal data. The PII definition is that under the GDPR is any data related to an identified or identifiable natural person. In DPDP Act, data about an individual who is an identifiable by or in a relation or to such data. In CCPA, data that identifies, relates to, or could be linked to a consumer or household is called a PII data. Now for the consent requirement. In GDPR, explicit consent is required for SPII. Strict conditions for processing of the SPIs are put in GDPR. In DPDP Act, the consent requirement has to be free, informed, and specific consent required for all personal data. In CPRA, there is an opt-out model for SPII, right to limit use disclosure, opt-in for minors. The protection measures which are applied or required for under these three frameworks are for GDPR encryption, pseudonymization, DPIAs, and access controls are mandated. In DPDP Act, reasonable security safeguards, breach notification within 72 hours are mandated. Wherein in case of a CPRA, data minimization, purpose limitation, consumer rights enforcements are required. Now let's look at a key aspect for a sector-wise comparison of the key data protection across these three regulatory laws. For healthcare, under the GDPR, it requires explicit consent for processing sensitive health data. DPIs are mandatory. Strong encryption and access controls are also mandatory. Under the DPDP Act, for healthcare sector, verifiable parental consent for minors is required. Restriction on behavior profiling is there, and breach notification to the board within the 72 hours is required in terms of healthcare data. For CCPA, sensitive health data must be protected. Consumers can limit use and disclosure. Opt-out of sale and share is required. In terms of social media, for under GDPR, profiling and behavior tracking requires consent. DPI is for large-scale monitoring, transparency in algorithm, where DPDP Act states puts significant fiduciary obligations, ban on behavioral targeting of children, age verification is required. While CPRA mandates opt-out of cross-content behavioral advertising, SPI restriction, ADMT governance requirement. Now let's explore some of the common tenets of global privacy laws. There are 6 principles of global privacy laws: lawfulness, fairness and transparency, purpose limitation, data minimization, accuracy, storage limitation, integrity and confidentiality, and an accountability, which is the 7th one, which is a bonus principle. Now let's look at some of the challenges in global data privacy that these days are faced. There is a varying definition and scope of PII. Different jurisdictions define PII data differently. For example, GDPR takes a broad view, including online identifiers like IP addresses, whereas some laws which are narrower in scope. This inconsistency makes it difficult to adopt a single universal data classification policy. Second challenge is the cross-border data transfer restriction. Many regulations impose strict rules or outright ban on transferring personal data to certain countries unless adequate safeguards are in place. organizations must navigate adequate decisions, standard contractual clauses, and government restriction, all while ensuring the uninterrupted business operations. Managing consent across jurisdiction is another big challenge which all jurisdictions are currently facing. There are language and cultural barriers. Privacy notices, consent forms, and user rights communication must be clear, accurate, and culturally appropriate. Translating legal requirements into a plain language and that resonates the local user can be challenging at times. And keeping pace with the regulatory changes. Data privacy laws evolve rapidly with new regulations emerging and existing ones frequently updated. Organization needs continuous monitoring, legal expertise, align compliances framework to remain up to date and avoid costly non-compliance penalties. So, what is the way forward for the organization? The key challenges organization face is navigating global data protection landscape. Following step-by-step approach can be adopted by organization to develop and implement a comprehensive and adoptable data protection strategy that can accommodate varying legal requirements across jurisdiction. Conduct a data inventory and mapping is the first step. So you have to identify what is personal data is collected, where it is stored, and how it is processed. Second step is gap analysis. Compare the current data processing practices against the requirement of relevant data protection laws. Third step is policy and procedure development. Create and implement data protection policies, procedures, and standards. Fourth is implementing technical and organizational measures. You have to put in place appropriate security safeguards to protect the personal data. Training and awareness. You have to educate employees of your organization on the data protection obligation and the best practices. Sixth is establishing data subject matter rights mechanism. Ensure processes are in place to handle data subject requests, such as access, rectification, erasure. Seventh is developing a breach response plan. You need to have a you have to first create and comprehensive breach response plan, and you also have to test it periodically, and you have to report the data breaches in a timely manner as required by the law. And last but not the least is conducting the ongoing monitoring and auditing. Regular reviews and updates of data protection practices ensure continuous compliance. So, friend, in order to conclude, I would like to say GDPR is the most comprehensive and globally influential with strict consent and accountability mechanism, and it enforces the same. For DPDP Act, it is more of consent centric and evolving with a strong emphasis on digital sovereignty and national interest. Where CCPA is a consumer focus, emphasizing transparency, opt out rights, and SPI protection. Hope the podcast was informative. Thank you very much for your time.